I call to order this hearing of the Subcommittee on Competition, Antitrust, and Consumer Rights, entitled The Impact of Consolidation and Monopoly Power on American Innovation. Good afternoon. I want to welcome our witnesses, and I thank Senator Lee and his staff, as well as my staff, for planning this hearing. Innovation is part of the American spirit. It is the core of the American spirit. Innovation generates new opportunities and new hopes for businesses, workers, and families. Breakthroughs in science and technology has given us the vaccines that are getting us through the pandemic and driving the development of clean energy solutions to take on the climate crisis that we see every day as my state is getting a record heat wave and thunderstorms in the middle of December today. Emerging technologies like artificial intelligence are driving innovation across our economy. Of course, some of our economy's largest companies began as startups with new innovations, and we continue to see innovations. But we also have to remember that innovation is all about competition and bringing in new players to innovate, that if we just simply have monopolies over time, we do not get the innovations that we need. I think history shows us with the story of the breakup of AT&T and the innovations that we saw after that in terms of everything from the cell phone industry on. Looking back at our history, it's always been innovation that has fueled the American economy, from the railroad and the telegraph to smartphones and the internet. America would not be where it is today without innovations and strong competitive policy and laws on the book. But the innovation that is vital to our American economy cannot thrive without open competitive markets, because it's competition that pressures manufacturers to invest in research and development, to constantly innovate, to improve their products and introduce new products to compete. It's competition that provides opportunities for entrepreneurs to develop new ideas and start new businesses, and for young people to dream about new possibilities. But in recent years, we have seen the growth of monopoly power across the American economy, from cat food to caskets. Dominant players are using their power to maintain monopoly positions and thwart competition. Between the early 1980s and the last few years, the rate of new business formed in the U.S. fell. Now, data suggests that as we move out of this pandemic, Americans are starting new businesses at historic rates. That's great. Remember, we fell by 40% before. But businesses can start, but can they really grow to the point of being competitive? And that is something that we want to talk about today. Why invest in innovation? Why spend on research and development? Why start a new business if the market are controlled by a handful of dominant companies that control access to customers and have the power to suppress new businesses? Monopoly power threatens to choke off innovation. Over the last several decades, companies like Google and Amazon, Apple, Facebook, and Microsoft have created many great innovations. We went from the Wall Street Gordon Gekko days with his cell phone, affectionately known as the brick, that weighed 2 pounds and was 13 inches long, to cell phones the size of a watch. But while these tech companies were once scrappy startup innovating to survive, they are now the largest companies the world have ever known. They are still innovating and introducing new products, yes, but they are also gatekeepers, and that is the thing that we need to focus on. Gatekeepers that use their powers to stifle competition and innovation by their competitors and the businesses that have no choice but to use their services. We don't want to stop them from innovating. We don't want to destroy them. We just want to stop them from stopping others from catching on and innovating. Just yesterday, the Competition and Markets Authority in the UK issued a report highlighting that Apple and Google's control over app stores can limit innovation and choice and lead to higher prices, none of which is good for users. Small businesses develop new and innovative products for American consumers, and many of them advertise on the gatekeepers, Facebook, Google, Amazon. But can they sustain this incentive to innovate when Amazon or Apple knocks off their products and puts their own copycat products first in search results? Developers across the country are creating useful new apps for consumers, but they are sometimes slow to reach users because Apple takes weeks or months to review them before putting them up on the app stores. And if they want to reach iPhone customers, they have no choice because there's no other way into the market. Once upon a time, disruption was a good thing in tech. New companies on the block were proud of breaking into markets and changing the status quo, adopting company mottos like move fast and break things. Now, disruption is what they seem to fear. Before Facebook bought Instagram, Mark Zuckerberg wrote in an email that if Instagram were to, quote, grow to a large scale, quote, they would be very disruptive to us. We will never know if an independent Instagram would have found solutions to the massive privacy and content and children's problems we are seeing today. Why? Because Facebook bought it. And our laws are not equipped to address this kind of conduct. Current law allows judges to consider harms to innovation in antitrust cases, but they rarely do. That's because judges often demand an impossibly high standard of proof, which can be hard to show when you are talking about how innovation in the future might be harmed. We need solutions to these problems. The Competition and Antitrust Law Enforcement Reform Act would update the legal standard to prohibit harmful mergers across the economy, shifting the burden to dominant companies to prove that their acquisitions don't threaten competition. This doesn't mean they're not going to purchase other companies. They are. It just makes them have to prove that they don't hurt competition. To address the issues in the digital economy, I joined Senator Blumenthal and Senator Blackburn to introduce a bill that will open up the twin app store monopolies that Apple and Google operate. That's the Open App Markets Act. I'm also proud of the bipartisan legislation that Senator Grassley and I have introduced to prevent dominant digital platforms from engaging in behavior that harms competition by favoring their own products or services just because they own them. We have authors from across the political spectrum on that bill. Someone referred to it as the Ocean's 11 of sponsors. American businesses and consumers need a renewed and strengthened antitrust movement. They need a movement grounded in a pro-competitive economic agenda that will actually help capitalism and innovation across the economy. We must act now to protect American innovation and promote competitiveness in tech and healthcare, and indeed in all sectors of the economy. I'll now turn it over to Ranking Member Senator Lee, and I note that our chair is here. We're grateful he's here, Senator Durbin, and if you would like to say a few words as well when Senator Lee is finished.
Thank you, Chair Klobuchar. I'm a huge advocate of the consumer welfare standard, and I've also made clear that in no universe should application of that standard be limited to a focus on price and output. Those are factors to be considered. They are not the exclusive list of things to be considered when applying the consumer welfare standard. Innovation effects are a perfect example of how antitrust enforcers and also courts can and should apply a more comprehensive understanding of consumer welfare. When competition suffers, so does innovation. And when innovation suffers, that harms consumers. In fact, one might say that competition is itself the mother of innovation. Competition really can't occur, especially in our society, in our economy today, without a lot of innovation. Monopolists and other large, unthreatened incumbents feel no need to improve their products or to develop new ones, not as long as consumers continue to pay for the old ones. And as long as that expectation holds firm, they're not going to feel it. They're even less motivated to develop products and services that create new markets that would cannibalize the old. There's no reason horse and buggy manufacturers, it is no reason. It shouldn't come as a surprise to us. In other words, there is a reason that it wasn't horse and buggy manufacturers who came up with the automobile. Ensuring that competition thrives and results in useful innovation depends mostly on the competitors and innovators themselves, but it also requires two important things from government. One is to protect the free market by vigorously enforcing antitrust laws to prevent harmful consolidation and anti-competitive conduct. And two, to step back and refrain from regulation and market interference of the sort that tends to disrupt the competitive process and make innovation harder. In fact, when the antitrust laws are properly enforced, the need for government regulatory intrusions elsewhere diminishes. My own state of Utah has been particularly successful at this, which is one of the reasons why U.S. News and World Report rated Utah's economy as the strongest out of the 50 states this year. Utah is at the forefront of protecting consumers from anti-competitive conduct, including by joining antitrust lawsuits against Google and Facebook. And I commend Utah Attorney General Sean Reyes for joining in that, and commend the Antitrust Division of the Department of Justice for its actions, and also the Federal Trade Commission insofar as they've undertaken steps in these areas. I commend them for that. And our state has seen its pro-free market regulatory approach attract businesses and investors from around the country, resulting in a growing tech community and a vibrant startup ecosystem. This has occurred in part because of Utah's historic approach toward regulation, which is a light touch one, and it's been accelerated of late with the Regulatory Sandbox Initiative that's been adopted by our state legislature at the behest of a number of zealous proponents, including the original proponents at the Libertas Institute in Utah. In 2020, Utah startups racked up over $30 billion of liquidity events just in 2020 alone. This is a massive vote of confidence in the innovation that's happening in the Beehive State. This year has seen an additional $14 billion in investment so far, including 7 IPOs of Utah companies like Owlet and Recursion Pharmaceuticals. Owlet is a company started by Brigham Young University graduates who started it out of their garage. And in this garage, they developed a baby sock that monitors blood oxygenation and alerts parents to any problems. Recursion was founded in 2013 and incubated at the University of Utah, where it developed technology to significantly accelerate drug development. Utah is quickly becoming the face of competition and innovation. I do worry, however, that DC bureaucrats may spoil the party for everyone. Antitrust enforcement that goes beyond stopping mergers and conduct presenting harm to consumers, and instead seeks to punish anything and everything that displeases progressives, displeases whatever administration happens to be in power, or looks solely at what is big at the moment as looking too big in the eyes of antitrust regulators. These are all things that threaten to do more harm than good. So too do regulations that entrench incumbents and create barriers to entry and stifle innovation. Owlet, for example, the company I mentioned a moment ago that was started in a garage by some BYU graduates, has been hampered by overregulation and ineptitude at the FDA, meaning that Owlet's products will temporarily be unavailable in the United States. That, in turn, means fewer moms will rest easy at night. Fewer jobs will be created in my home state, and less money will be reinvested in research and development for American consumers. All of this because of regulatory overreach. Regulatory overreach protecting no one except market incumbents elsewhere. When I hear stories like this, it makes me angry, makes me sad. It also makes me wonder about how many startups federal agencies kill that we never even hear about. I look forward to discussing with today's witnesses some of these issues, including issues about how the federal government can follow in the footsteps of Utah by enforcing the antitrust laws to the benefit of consumers and ensuring along the way that regulatory overreach doesn't stifle innovation and offset the gains we make with antitrust laws. Thanks.
Well, thank you very much, Mr. Senator Lee. I didn't know that about your great state of Utah, where I spent some time this summer. So then, of course, like many senators, I looked up where my state ranked. And you are correct that Utah ranks #1 for economy in that U.S. News, and you rank #3 for best state overall. But guess what state ranks #2? Minnesota.
Foiled
With
again.
that, I will, and Washington State is #1 with a number of factors, but a point of great pride. I think it's interesting. There may be a reason you two and I, the two of us, unite on this issue of innovation because it drives a lot of what's great about our states. With that, I turn it over to Senator Durbin.
Thanks very much, Senator Klobuchar, for your leadership. Thanks, Senator Lee, for making it a bipartisan effort. This is the 7th hearing of this subcommittee on competition and continues to illustrate the need to promote competition to protect consumers. It's an article of faith for most people that competition leads to innovation, and competition and innovation lead to lower prices for consumers and improved product lines. I believe that. That's why I'm co-sponsoring the Klobuchar legislation. If you look at the reality of the marketplace, one of the things you see right away is pharma. Pharma, of course, with the patent protections, has virtual monopoly on the sales of certain products. And when that protection expires, there's supposed to be competitors emerging who will then make the product cheaply and give the consumers a break in the process. It's kind of an interesting balance, a protected monopoly that then evolves into a competitive marketplace. And we look at the lengths that pharma goes to protect the drugs that they developed and to extend this patent protection over and over and over again through a variety of different ways. And we realize there's money to be made by stifling this competition and protecting their property rights. Ms. Hein, who is, I believe, going to join us from Switzerland, is that right?
I think, yes.
She is. That's what I read.
Yes.
Yes, well, I read your testimony, and she takes exception to several of the things that I just said. She believes that, I think, I don't want to put words in her mouth, but what I read her testimony say is that people are developing these products and companies to build them, not for the purpose of going public and making a competitor, but for the purpose of being acquired by an even larger company. And according to her, acquisitions are 10 times more likely than any of these new firms going public. So I'll let her develop her line of thinking there, but it seemed to be that having some large corporation that's going to pay a premium to take over your fledgling business is more enticing to most innovative entrepreneurs than hanging around and watching your next Google emerge. It'll be interesting to see what her argument may be. But I think the bottom line, and it has been since a senator named Sherman back in 1890 put together an Antitrust Act, is that we believe in the marketplace, but we believe in a fair marketplace with real competition is in the best interest of innovation and consumer cost. So I hope we can pursue that thought here today and see if there are any dissenters.
Thank you very much. Thank you very much, Senator Durbin, for being the co-sponsor of the bill and your devotion to competition issues. So I think we'll introduce our witnesses now. We'll start with Dr. Moss, who is the president of the American Antitrust Institute. As an economist, Dr. Moss has studied antitrust issues affecting markets across the economy, especially in digital technologies and healthcare. She previously worked at the Federal Energy Regulatory Commission on the agency's competition analysis for electricity mergers. Alex Harmon. Mr. Harmon is the competition policy advocate at Public Citizen, where he works to address concentration and market power across industries, especially in the tech industry. Previously, he worked in the Obama administration, including also worked in Congress, where he was chief counsel to Senator Hirono, a beloved member of this committee. But we also have with us Eric Mizukovsky. I like long names with a lot of vowels, so we welcome you. Mr. Mizukovsky is the founder of Beeper, a startup that allows users to access their messages from multiple services in a single application. Previously, he worked for Y Combinator, a startup tech accelerator, and founded another startup that developed smartwatches. So it's kind of right exactly what we're talking about here with startups. Next, as noted by Senator Durbin, Bettina Hine is with us. Ms. Hine is a software entrepreneur who has built technology companies in both the United States and Europe. She is most recently the founder of a digital health startup, and she previously founded startups focused on speech technology and video advertising. Finally, Roger Alford is a professor of law at Notre Dame Law School, where his teaching includes international trade, international antitrust, and comparative law. Previously, he served as the Deputy Assistant Attorney General for International Affairs with the Antitrust Division of the U.S. Department of Justice from 2017 to 2019. If the witnesses could please stand and raise your right hands, including the witness who is remote. Do you swear that the testimony you will give before the subcommittee shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can be seated, and I will now recognize the witnesses for 5 minutes of testimony each. Dr. Moss, you can proceed.
Thank you, Senator Klobuchar, and Chair, Ranking Member Lee, and members of the subcommittee. It is an honor to be here today. I'll start by saying that competition drives innovation, and innovation drives productivity and economic growth, and therefore competition drives economic growth, the backbone of the U.S. economy. But evidence shows that innovation in the U.S. may be slowing. A number of reasons might account for these changes. One is the financial community's laser focus on shareholder returns, which diverts attention away from growing value through R&D and toward short-term profits. Another reason is weaker antitrust enforcement over the last 40 years, which has spurred businesses to acquire R&D versus developing it organically. A likely byproduct of rising concentration has been a loss of innovation competition. Policymakers should be deeply skeptical of arguments that bigness generates innovation. Because dominant firms and oligopolies do not fear losing to an innovative rival, they have weak incentives to stay ahead of the innovation curve. To be sure, they do engage in some innovation, but it is very different than what we would get through robust competition. For example, less competition means dominant firms and oligopolies avoid developing products that cannibalize their own product lines. Instead, they focus on innovation that protects their market positions. Oligopolies can also collude on technology decisions. They can divide up R&D markets and strike anti-competitive licensing agreements. All of this limits innovation and keeps prices high. Here are some leading examples of innovation competition concerns. First, the digital business ecosystems are defined by a growth by acquisition model, whereby they acquire rival disruptors to fortify their platforms or expand cloud infrastructure. But many of these deals are so-called killer acquisitions, which neutralize disruptive innovators. For those innovators that do operate on platforms and networks are often the target of discriminatory conduct, which harms innovation. A second example is horizontal and vertical integration that has created firms with massive wingspans that cover multiple levels in a supply chain. Innovation competition concerns were featured in government complaints in deals like Bayer Monsanto and AT&T Time Warner, but not enough attention is given to the higher barriers created for smaller rivals to enter and get a foothold in those markets. Finally, we know that market-wide probability of invention in pharmaceutical R&D increases with the number of competing firms. And that competition between R&D pipelines is essential for innovation. But over the last 25 years, the FTC has allowed 66 mergers worth $1 trillion of branded and generic pharmaceutical firms. Most were in highly concentrated markets and settled with targeted divestitures, leading to assets changing hands within a shrinking group of drug manufacturers. Many of those very firms are defendants in antitrust litigations and criminal price-fixing conspiracies. I'll conclude my remarks with 3 policy priorities. First, we need antitrust enforcers to bring what I call more standalone innovation competition cases. That means innovation plays the starring role in the case and is not simply tacked on to concerns over higher prices. To be sure, we have seen those cases in Facebook and Google, Visa Plaid, John Deere Precision Planting, and NVIDIA ARM, but we need more. Second, enforcers may be reluctant to bring innovation competition cases because they perceive high litigation risk. This risk is amplified by the court's deference to claimed merger benefits, which stack the deck against plaintiffs. Yet we know from business research that few merger benefits are ever achieved, as illustrated most recently by AT&T's post-merger spinoff of Warner Media less than 3 years later. Discounting efficiencies claims, especially in mega mergers, could spark more innovation competition cases. Third, current approaches to showing harm from acquisitions of smaller disruptors are inadequate. Aside from a high evidentiary standard, little attention is paid to evidence of intent or that dominant firms take out innovative rivals to maintain their market positions. Stronger or different standards are needed. So antitrust has a way to go on innovation competition. Invigorating enforcement will require support from Congress, including shifting the burden to defendants to justify mega mergers, stronger standards for acquisitions that neutralize disruptors, and perhaps even lowering the HSR thresholds for acquisitions by the fast-growing digital players. Finally, I would like to say that the problem of fear and intimidation in our markets is growing at an alarming rate. Smaller rivals fear retaliation from dominant firms and oligopolies if they complain to public or private enforcers about abusive conduct. This hamstrings their essential role in antitrust enforcement and has a direct adverse effect on innovation competition. Thank you, and I look forward to your questions.
Thank you very, very much. Next up, Mr. Harmon.
Thank you, Chairwoman Klobuchar, Ranking Member Lee, Chairman Durbin, and other members of the subcommittee for the opportunity to testify today. I'm Alex Harmon, Competition Policy Advocate for Public Citizens Congress Watch Division. We're a national nonprofit organization with more than 500,000 members and supporters. For the past 50 years, we've represented the public interest on a broad range of issues, including competition and consolidation of corporate power. Thank you for your leadership in continuing to examine one of the most critical issues of our time, the harms to consumers and our economy that result from the failure of our antitrust laws to meet the challenges of the day. For decades, we've seen the rise of market power of big tech companies and an alarming increase in consolidation throughout the economy, which has stifled innovation. We appreciate the thoughtful work of the subcommittee to address this serious problem through today's hearing and its prior work. I'd like to dispel the myth that large, consolidated industries, particularly big tech companies, somehow foster innovation and American competitiveness. Or even more absurd, that addressing the problem of runaway consolidation and anti-competitive conduct would stifle innovation. Empirical evidence and common sense show us that the opposite is true. When companies face less competition, they invest less in R&D. They are in turn less likely to innovate in ways that benefit consumers and the economy. And all too often, companies that depend on these gatekeeping firms to reach the marketplace slash jobs and cut back on developing new products and services because they must pay steep monopoly rents as a cost of doing business. As the founder of one business said, it feels like we're treading water with cement blocks around our feet. This point bears repeating. Less competition leads to less innovation. Less innovation hurts consumers and the entire economy. In the highly consolidated tech sector, this means we get only marginal, incremental enhancements instead of breakthrough products and services that once defined the big tech companies. Although I'll focus my testimony on big tech's widespread dominance and abuse, the harmful effects of monopoly power on innovation are not limited to digital platforms. Studies of the agriculture and pharmaceutical industries also show that more consolidation leads to less R&D. Decades ago, these companies sought to disrupt stagnant industries and succeed where incumbents failed. But these once scrappy disruptors have grown to be some of the largest and most valuable companies on the planet. Now their businesses are focused on maintaining or building their dominance instead of building new products or services, ensuring that they cannot be displaced or disrupted by the next generation of startups. Tech startups often cannot get funding if they are in the so-called kill zone that surrounds big tech. If a startup attempts to operate in an area that is seen as too close or a threat to one of the companies, investors assume that they will fail because of the likelihood that the big tech companies will crush such threats. A recent report by the FTC confirmed what we largely already knew. These firms have acquired more than 600 companies in the last decade. This innovation by acquisition has the insidious effect of displacing internal R&D and locking up innovative technologies under the control of big tech. In the last 2 years, Meta, while facing an FTC lawsuit over its acquisitions of Instagram and WhatsApp, has acquired 5 different virtual reality companies, seeking to cement its dominance in this space for years to come. In addition to engaging in hundreds of acquisitions, large tech companies have abused their dominance to make it so that any business that needs access to their platform either cannot compete at all or can only do so under difficult or unfair conditions. These problems must be addressed immediately, not 5 years from now, not even a year from now. Across the political spectrum, Americans overwhelmingly agree that big tech must be reined in and demand action. Bipartisan legislation introduced earlier this year in the U.S. House of Representatives, as well as other bills introduced by members of this subcommittee, would help address the problems I've laid out. These bipartisan bills include the American Innovation Choice Online Act, introduced by Chairwoman Klobuchar and Ranking Member Grassley, which would establish fair rules for competition online. The Platform Competition and Opportunity Act, introduced by Chairwoman Klobuchar and Senator Cotton, would prohibit certain anti-competitive mergers by the big tech companies. And the Open App Markets Act, introduced by Senators Blumenthal and Blackburn, would ensure more opportunity for competition in the mobile app markets. Public Citizen supports all of this legislation. These bills would help unleash innovation. The promise of new, faster, and better products and services has hit a wall of big tech monopolies and their monopolistic market distortions. It is time to meet this challenge and correct the failure of our antitrust laws. Thank you again for the opportunity to testify on this important topic, and I look forward to any questions you might have.
Very good. Thank you. Mr. Mizukovsky.
Chairwoman Klobuchar, Ranking Member Lee, and members of the committee, thank you for the opportunity to testify. My name is Eric Mizukovsky, and I'm the founder of Beeper. We are a 1-year-old startup with 20 employees. Beeper is a new chat messaging app that enables you to chat on 15 different chat networks. It's a simple and efficient way to communicate with your friends, family, and colleagues. Beeper is actually my second startup. Previously, I founded Pebble, where we invented the smartwatch and did over $200 million in sales. But after trying to compete with the Apple Watch on an uneven playing ground, we were forced to sell the company to Fitbit in 2016. This hearing represents a rare opportunity to examine issues at the heart of innovation, whether new ideas can compete fairly in markets distorted by big tech companies. I started building Beeper because I was tired of having to keep track of which apps my friends were on. I wanted one single place where I could message anyone I knew. Another motivating factor for us is security and privacy. 80% of chat apps today do not offer encryption to their users. We're building Beeper as an alternative to chat apps run by large social networks that exist solely to capture more user data. Today, we have several thousand people beta testing Beeper, but we're finding it increasingly hard to connect Beeper to chat networks run by big tech companies. Our concerns over a level playing field are not simply theoretical. In particular, we're worried about Facebook. They've taken aggressive actions against companies in the past that have tried to interoperate with their network, including suing new entrants over CFAA violations, copyright, and other claims. My goal here today is to support legislation like Senator Klobuchar and Senator Grassley's American Innovation and Choice Online Act and Senator Blumenthal and Senator Blackburn's Open App Markets Act. I believe increased innovation in the chat market would result if these bills are passed. Chat is now the dominant form of communication. Just ask any teenager if they've sent an email or made a phone call in the last week. Today, almost all major chat apps are controlled by big tech companies, and most were created over 10 years ago. They're old, tired, and lacking in new ideas. For example, WhatsApp's most recent new feature was status, which they copied from Snapchat. The reason why little innovation happens in chat is because of lock-in network effects. Over 3 billion people use chat every day, but on most major chat apps, you can only chat with people who are on the same app. Most users do not use these apps because of specific features. They use them because their friends are on the app. This lock-in network effect prevents new competitors with innovative ideas from getting off the ground. Big tech companies also stifle users' freedom by making it practically impossible to switch networks. For example, when WhatsApp changed its privacy policy earlier this year, many people tried to leave the platform. But it's very difficult to move group chats and chat history from WhatsApp, so most people stayed put. Big tech companies also do not transparently explain to users what happens with their personal data. For example, Apple backs up users' encryption keys to their iCloud servers by default. And just last week, it was reported that Tim Cook did a secret $275 billion deal with the Chinese government, which may have included moving certain iCloud servers to China. Finally, the chat market itself is distorted. Big tech companies give away their chat products for free because chat is a reliable way to lock users into social platforms that then mine their user data. At Beeper, we have somewhat of a revolutionary business model. We charge users money in exchange for a service. Luckily, this committee is currently considering legislation that provides straightforward solutions to these problems. First, big tech companies need to provide interoperability on their chat networks. Interoperability will give users the freedom to communicate with friends and family who are on different platforms. This is not a radical concept. Email is interoperable. Gmail users can send email to Outlook or Yahoo, no problem. Secondly, in order to have the freedom to switch networks, users need to be able to exert control over their own accounts and personal data. I firmly believe that the bills this subcommittee is considering represent a critical step forward towards ensuring a competitive playing field for new startups. Thank you for your time, and I look forward to answering any questions you have.
Okay, thank you very much. Remotely with us, Ms. Hine.
Thank you so much. Chair Klobuchar, Ranking Member Lee, Chairman Durbin, and members of the subcommittee, thank you for your invitation to me to testify today. I'd like to begin by thanking you, Madam Chair, for your leadership regarding entrepreneurship and innovation issues as the co-chair of the Senate Entrepreneurship Caucus. In particular, your work regarding the unique challenges that confront women entrepreneurs, and there are many, is especially appreciated. I want to begin by emphasizing that I am not a policymaker or an antitrust attorney. I'm a career-long startup entrepreneur. I'm currently building my third company, and it has 15 people right now. I'm here to share with you my perspective regarding the likely impact of acquisition restrictions and other market interventions on entrepreneurs like me. Thriving entrepreneurship is critical to a strong and growing economy. You all have mentioned that. But entrepreneurship is also risky. A third of new businesses fail by their second year, half by their fifth. For fragile startups, there are three principal outcomes: fail, go public, or be acquired. Failure is the most common outcome. Many entrepreneurs dream of taking their company public, but most startups never achieve the scale that going public requires. Acquisition, therefore, is by far the most likely avenue for entrepreneurs and their employees to realize the value of what they've created through years of hard work and sacrifice. In a typical year, 10 times as many startups are acquired as go public. Importantly, acquisitions also enable startup investors, which I actually myself do as well. I invest in startups with the money that I've earned before. Acquisitions enable startup investors to reclaim their invested capital, realize any gains, and recycle their capital into the next generation of startups. My principal concern here today is that the Platform Competition and Opportunity Act and bills like it that restrict acquisition of startups by larger companies will profoundly undermine the incentive for entrepreneurs to take the personal and financial risk of launching a new company. And if investors are unable to liquidate their investment to reclaim capital and potential gains, they won't risk their capital by investing it in companies like mine in the first place. Without investors, there is no Julie, there's no startup ecosystem. I'm also concerned that the bill will likely accomplish exactly the opposite of what it intends by tilting regulatory circumstances in favor of the larger companies it targets. The risk of this unintended effect is very real because it has happened before. In the 6 years following the enactment of Sarbanes-Oxley, Small company IPOs valued at 50 million or less plummeted by 92%. And that would have included Apple, Microsoft, etc. in their infancy. For me personally, Sarbanes-Oxley at the time meant giving up on my girlhood dream of running a public company. Similarly, 10 years after the enactment of Dodd-Frank, large banks are bigger and more profitable than ever, while more than 2,000 community banks have disappeared and lending to small businesses has decreased significantly. The Platform Competition and Opportunity Act risks similar unintended consequences. By dramatically increasing the regulatory hurdle and compliance costs of acquisition, the act would likely advantage large incumbent companies who have the money and teams of lawyers to navigate the new legal landscape. Many smaller acquirers would be shut out. Additionally, large acquirers will pay for the costs of the new requirements by simply reducing the value of transactions. In other words, reducing what they're willing to pay for companies like mine. Large technology companies won't be hurt by this legislation. Entrepreneurs like me will be. And American households, consumers, and investors who rely on innovations entrepreneurs contribute will also be hurt. Madam Chair, Ranking Member Lee, to protect competition and innovation, we don't need the blunt sledgehammer of sweeping legislation with all of the risks of unintended consequences. Rather, we need a surgeon's scalpel to carefully dissect, understand, and address the unique circumstances of each proposed acquisition. And that scalpel resides with the regulators. As you said at a recent Center for American Progress event, Madam Chair, put the right people in those agencies and give them the resources they need to do their job. Thank you very much for this opportunity, and I'm looking forward to your questions.
Right. Thank you very much. Next up, but I will note the number of the people that are in the agencies doing their jobs or have done their jobs, including the former head of the Antitrust Division, Macon Delrahim, under President Trump, believe that we need to make some changes to the laws so they can actually do their jobs to enforce the laws. With that, I'll turn it over to Professor Alford.
Thank you, Chairman Klobuchar, Ranking Member Lee, and members of the subcommittee. Thank you for inviting me for the opportunity to be here. You have my written testimony, so I'm just going to raise a few key points in my opening remarks, and hopefully we can go into more detail in the Q&A. I was going to begin by talking about the consumer welfare standard, but my position is very similar to what Senator Lee said, so I will skip my comments with respect to the consumer welfare standard, and let me begin by discussing innovation and quality fixing. Harm to innovation raises the issue of powerful market actors engaging in what may be called quality fixing. Why do we focus so much of our attention on price fixing, but we almost never discuss quality fixing? Why are we not more concerned about big tech companies working through trade associations to collude on quality, such as a diluted common privacy standard? Why have there been no subpoenas from Congress or government enforcers investigating collusion on quality? Rare are the cases, such as the European Commission and its $1 billion fine against 5 European automakers for colluding with one another to delay introducing clean energy innovations. Second, antitrust law should be more particular about innovation involving startups. We should embrace the fact that a common exit strategy for startups is to be acquired. But at the same time, we should recognize that VC money is often unavailable to a startup that tries to compete with a dominant firm, and if it does try to compete, that dominant firm may seek to acquire it to eliminate a competitor. The DOJ's challenge of Visa's attempt to acquire Plaid is one recent example, and so too is the FTC's complaint against Facebook regarding the Instagram and WhatsApp acquisitions. Third, innovation is of particular concern in the context of mergers and sometimes requires innovation divestitures. To address innovation concerns in the Bayer-Monsanto merger, for example, the DOJ required the merging parties to divest certain intellectual property and research capabilities, including pipeline R&D projects. This structural remedy was necessary to maintain competition in emerging product lines. Fourth, sometimes incumbents seek to forestall innovation to keep prices high and to reduce output. The real estate market is a quintessential example. It is dominated by the National Association of Realtors, which imposes mandatory rules that keep prices high and reduces innovation. As a result of NAR's rules that require a seller to pay a buyer broker's commissions, brokerage fees for the sale of an average home in the United States are between $20,000 and $24,000, compared to $14,000 for the same priced home in other developed countries. Imagine the impact on the average American if they could purchase homes more efficiently, enhance their job mobility, and build home equity easier and earlier. Online listing services such as Zillow have offered some innovation in searching for homes, and discount brokers such as Redfin and Rex offer technological solutions. None of these innovations allow consumers to buy and sell homes with the kind of transparency, functionality, and efficiency commonplace in other online marketplaces. There is nothing like Robinhood or E-Trade in the real estate market. This is all because of NAR's mandatory rules that forestall innovation. Finally, let me briefly discuss exclusionary innovation. Innovation is not always good. Sometimes innovation excludes competition. With respect to online platforms, search algorithms often are designed to self-preference. Technologies often are not interoperable. Data portability raises similar concerns. Big tech frequently introduces, quote, innovations to degrade the quality of competing products and services. Let me offer a concrete example from the Texas v. Google complaint. Google uses its power in the online digital advertising marketplace to force publishers to use Google's exchange, which charges extremely high transaction fees. These fees hurt publishers' revenue, so publishers developed some code to allow them to reduce fees and route their inventory to multiple exchanges. Google was upset by this. They called it an existential threat, so they introduced a series of innovations to make it slower and harder for publishers to use competing exchanges. In short, Google introduced numerous innovations for the express purpose and result of excluding competition. Let me close by saying that one certainly has the impression that there is a growing bipartisan consensus that big tech companies have abused their market power in excluding innovation and that something must be done about it. That is reflected in various lawsuits filed and prosecuted by the Trump and Biden administrations, as well as almost every state attorney general. It is also reflected in the various bipartisan legislation that has been introduced in the Senate and in the House. Thank you very much, and I look forward to your questions.
Very good. Well, thank you, all of you. I think I'll start with you, Mr. Mizukovsky, because I was struck by your testimony about how innovative developers like yourself, you can come up with a product, you can get it to market, you start a new business, bright and shiny, and then you always come up against some kind of a wall. Could you talk about what your experience has been interacting with dominant platforms in more depth, like Apple, Google, and Facebook? And one of the things I was thinking about, which maybe you can comment on, when you talked about how when you do emails, you can, you don't know that you're dealing with a different company or whatever it is. And then I was thinking about how when you do chats, it comes up in different colors. And it would be like with emails, you had 10 different colors and they would come up in different ways. Whereas Apple has to point out, like, it's not their phone you're dealing with. And that often some of these are harder to read for non-iPhone users. And I was just thinking how ridiculous that is compared to email or other forms of telephones, for instance, or cell phones. You don't have like a buzz in the background when you try to call someone from a different cell phone company, or a little bing goes on. You're not on our network, sorry, good luck. Could you talk about this?
Thanks for the question, Senator. I'll answer the last one first and then move to the first one. I think what you're referring to is the iMessage green bubble versus blue bubble situation. You probably have experienced when you're sending a message from an iPhone to an Android user, it shows up as a green bubble. Yeah, this is a real thing. While I was doing research for this, I actually found that the color differentiation between the text on a green bubble actually fails Apple's accessibility standards, which means that it's technically harder to read a message to someone who has an Android phone than an iPhone. And these little things add up to make it more difficult to communicate. You may recall 20 years ago when cell carriers used to limit SMS or text messaging between carriers. So, for example, if you had an AT&T phone, you couldn't send a text message to someone who had Verizon. That's kind of the world that we're living in today, and it feels a little bit weird to be in 2021 and still have these barriers between us as we communicate. Regarding your question about the walls that have been thrown up, my first company, Pebble, we made smartwatches. We were building a product that competed squarely with Apple's Apple Watch. On Android, we were able to get access to the system features that we needed to deliver a good user experience. But on Apple products, we simply weren't able to get the same level of access that products like the Apple Watch enjoyed. This made it really hard to compete. And since Apple controls both the App Store as well as the operating system, it was hard to build an accessory that worked with iPhone.
Mm-hmm. And could you talk a little bit, and maybe Ms. Moss, Mr. Harmon, you can join in on how that bill, the bill that Senator Grassley and I have introduced, which I see Senator Hawley here and is supporting it, as well as Senator Durbin, how that would help with some of this conduct, because you can't put your stuff above everyone else's. You can't rip off other products and then put it up against the product you've ripped off, and that you can't use data and other things. That any of you can comment on it, but the difference that it would make. Ms. Moss.
Thank you, and I'm happy to respond to that question. I think competition in this country has risen to the level of a public policy problem, and innovation competition is a big part of that, obviously. That means I think we need to use all of the tools in the public policy toolkit to address the concern of over waning competition through discriminatory conduct or other harmful types of behaviors. I would say that using multiple tools in the toolkit, strengthening antitrust regulation is a really important way to remove incentives to engage in discriminatory conduct or put constraints on it. That will absolutely level the playing field for smaller rivals, innovative disruptors operating on platforms, in terms of operability, in terms of access, in terms of the ability to reach consumers with their products and services. I would say one more thing very, very briefly. The tech sector moves very, very quickly, extremely quickly. And the big five are on the downside of an acquisition cycle. We are now studying at the American Antitrust Institute the companies that are what we call up-and-comers. These are companies who are acquiring cloud infrastructure, they are building out and fortifying platforms. And I worry about this next gen of up-and-coming digital techs that are going to be the powerful platforms in 3 to 5 years. So I think we want to think broadly about public policy initiatives and legislative reforms like the anti-discrimination bill, so that we are throwing our umbrella over all of the potential firms who could grow to be dominant platforms and who would engage in discriminatory conduct.
Mm-hmm. Very good. Anything you want to add, and then I'll turn it over to Senator Lee. Mr. Harmon.
Yes. I think the question you're asking about how would your bill specifically make it easier, I think if you are in the situation of a startup as Pebble was, and you look at how Pebble was treated, in a situation in which Apple would have to make their platform available for you to plug into, or would not be able to preference their product above yours, it's going to change your calculus in terms of how you approach developing a potential competitor.
Mm-hmm. Very good. Thank you very much. Senator Lee.
Thank you. Professor, I want to start with you, if that's all right. I saw you mentioned in your written testimony something that we looked at a hearing that we held last year, one that I called back when I was the chairman of the committee still. Among other things, we looked at competition and the state of competition in areas where consumers suffer as a result of two firms having control of every part of the ad tech space. And my office is currently working on legislation on this issue to address some of these problems, the conflicts of interest and competition that arise in digital advertising. Do you think this is an area where Congress could step in and solve the problem?
Yeah, thank you for the question. As I mentioned in my bio, I've been consulting with the state of Texas since August of 2019 on the Texas versus Google litigation. So I know firsthand, having followed this issue extremely closely, how real the problem is. And so, yes, I think the answer, litigation obviously is one possible solution. It's extraordinarily expensive. It takes an extremely long time. There are inordinate delay efforts on the part of Google with respect to that. You have introduced a venue legislation that will try to help expedite the process with respect to litigation, which I think is a great idea. But to answer your question, I think there's no regulatory context whatsoever here to deal with the advertising, online display advertising market. It is right now, Antitrust is doing all of the work, right? And so one possible solution that one could think about would be to think about how the similar conflict of interest have been addressed in the financial markets and how we could impose similar conflicts of interest concerns and limitations in the online display advertising markets. So, for example, you cannot own the New York Stock Exchange, right, and then be a monopoly player on the stock exchange as a broker, right? You cannot basically funnel all of the trades that happen on your brokerage firm into your preferred exchange, right? Right now, Google has exactly that issue. So there is no best interest duty, there is no duty of best execution, there's no limitations on insider trading, all of those kinds of things happen. And if you had a strict requirement that if you're going to own an exchange, you can't be a broker on either the ad or the sell side, that would be a useful addition, I think.
And yet currently they are. They
are definitely.
They run the exchange.
Yes, exactly.
And they're a broker.
Just to give you an example.
Both sides.
The NYSE is owned by Intercontinental Exchange, and they earn $3.6 billion from revenue from their exchanges. Google earns that in 5 days.
Right. And it's my concern is not with how much money they earn or how they do it. And it's not unlawful to be a monopolist in this country, but it is unlawful to acquire or maintain monopoly status through anti-competitive conduct.
Right.
It's hard to me to imagine a circumstance in which one can own the exchange platform and also be a buyer, seller, broker, dealer, and whatever other positions they might occupy in the meantime. It's hard for me to imagine how one firm can maintain all of those positions without something anti-competitive going on in purpose and effect. Ms. Hine, I'd like to turn to you next. You and your colleagues decided to sell your first company to an acquirer. Can you explain to my colleagues and to me why any entrepreneur would choose to sell their company rather than to continue to build it with an eye toward eventually going public?
Yes, I can do that, Senator. Thank you for your question. The circumstances of each company are unique, and it depends on how strong of a position one can build in the market. As we're discussing here, it depends on the technology and how market access works. And oftentimes there are also hurdles, like I spoke about in my testimony, Sarbanes-Oxley, for example. What that kind of regulation does is that it requires a significant amount of capital even to access the capital markets. So currently, startups that want to go public, typically before they go public, raise an additional $20 million in order to then be able to get over those hurdles, everything that they need to do. So with startup companies, it's very unique where they go. And I think that it should not be regulation that determines who I sell the company to or whether I can go public with it.
Deb, can I ask one follow-up there?
Of course.
It does sound like a somewhat similar situation to where you see a lot of pharmaceutical startups heading. As a result of FDA regulations, and the capital demands on competing, on starting and finishing clinical trials, most small innovators have to get acquired in order to scale up. And it sounds like you're describing a similar phenomenon.
Yes, definitely. There are a lot of regulatory hurdles, and obviously there's reason for a lot of these, but my point here is that there are a lot of unintended consequences, and I am afraid that my livelihood, which exists in creating innovative companies, will be impacted by regulations that I have to abide by, and I can't do anything to control the different thresholds. For example, is the $600 billion going to stay in place or being lowered, as Dr. Moss suggests? That all makes it very scary for people like me.
Thank you.
Senator Durbin.
Thank you. I'm trying to work through in my mind some historic analogies that will help me understand where we are today. And I guess the most profound evidence of government intervention in the marketplace in my lifetime that destroyed a monopoly and created innovation and entrepreneurship to a level that was unimaginable was AT&T, almost 40 years ago. And they busted up into regional companies and then spun off in many, many different directions. The mothership, AT&T, kept the production of telephones in Western Electric, which was an important part of the economy in the Chicagoland area, but now they're virtually non-existent. It isn't as if the iPhone people had to go to Western Electric to get permission for a new invention. The innovation just raced right past that model, that AT&T model that we had accepted as being virtually a public utility for so long in the United States. And it really gets down, Mr. Mizukovsky and Ms. Hine, to a question which I'm still hanging on to, and that is, what is your ambition as an entrepreneur and innovator? Is it to be acquired at some early point in the process and to make out like a bandit and then look to invest in others who are doing the same? Or is it to build the next iPhone or whatever it happens to be, some variation, which will take a lot of time and patience and investment to happen? According to Ms. Hine, the numbers are 10 to 1 that it's just to be acquired and move along to something else. And of course, the acquiring entity may have the best of intentions or the worst of intentions. It's hard for us to say. They may want to get you out of a competitive mode because you look menacing to them, or they may think this is such a great idea, we want to own it and we want to develop it. So, Mr. Mizukovsky, before Ms. Hine, would you comment on that?
Thanks very much for the question, Senator. Over the last 4 years, before I started Beeper, I was a venture capitalist at an early stage firm called Y Combinator. There, I helped invest in 400 companies over the span of 4 years. I will say that the best founders that I met at Y Combinator started their company to beat Google, not to sell to it. And I think that the limitations that are put on competition right now by some of these extremely large tech platforms are reminiscent of the AT&T days, especially for the earliest companies at their earliest stage. There's a story from the 1950s about a company that made an addition to an AT&T telephone called the Husha phone, which was a silencer that you would put around the phone, and they were banned from making it because AT&T had monopoly across the entire stack. That is very similar to companies like Apple, which makes the phone and also makes the App Store that distributes software. That's one of the reasons why we're supportive of Senator Blumenthal and Senator Blackburn's Open App Markets Act, which would go very far to leveling the playing ground for startups to compete on the App Store.
So give me your reaction to Ms. Hine's 10 to 1 number. It isn't even close. It's like 10 times as many are looking for acquisition as opposed to public offering.
When companies start out, they are definitely, at least the best founders that I know, are not looking for an acquisition. They're looking to build a product that could potentially change the world. That's one of the unifying factors, I think, among most startup founders. I think, I could speak to my case. In our case, our company, Pebble, we ran out of money. And so we had to sell the company as the only kind of exit. That was definitely not our intention when we started out. We had, very, very large and high goals. But having an exit route is, useful. It's not, definitely not the thing that we set out to do.
And I might say to Ms. Hine, if she's still following, I hope she is, I voted for Sarbanes-Oxley, and if you would go back to that moment in time when we had that debate, we were dealing with corporations that weren't shooting straight, and they weren't leveling with people in terms of the actual books, and people were losing a lot of money for misrepresentations. And it's true that there was, there'll be a difference of opinion even on this panel about what I have to say here. It's true that there are more regulations imposed, but the goal of those was similar to a goal of antitrust operations, so that we can have more honest dealings with the public than we did before. We had some terrible instances. I can go through the long list. Sure, it costs more for corporations to provide information that was reliable and trustworthy for consumers as well as investors. But if you want the integrity of the marketplace, which I think distinguishes the United States from many other countries, there's a price to be paid for it. And I just say that in defense of Sarbanes-Oxley.
Senator Grassley.
I'm just going to make a statement and ask one question in my 5 minutes. I'm a Republican, and everybody thinks Republicans should leave the free market alone, and I believe that it is the best source of innovation and competition. But where markets aren't working, antitrust enforcers should be able to take swift and decisive action to prevent anti-competitive activity. And if our laws need updating to provide better authority, then that's something that Congress should consider. I have strong concerns about competition in some sectors. That's why I've introduced several bills addressing concerns with competition in pharmaceutical marketplace. A lot of those have been bipartisan with Senator Klobuchar. Similarly, agriculture is an area where I've expressed concern for many years and introduced several pieces of legislation, including increasing transparency in livestock markets. I've been increasingly concerned with the dominance of the big tech companies and how that impacts competitors and consumers. Right now, there are only a handful of companies that control Americans' everyday lives, from what they see and read, how they interact online, how they purchase goods. These big tech companies are using their dominant monopoly power to favor themselves, and that monopoly power harms small businesses. It's not only preferencing and discrimination that's happening, but they also are using their power in the market to silence conservative voices. There must be a level playing field and fair competition. That's why I earlier joined the bill that Senator Klobuchar has already talked about, the American Innovation and Choice Online Act, to address competition concerns with big tech. This bill provides common sense rules to ensure that dominant online platforms don't unfairly preference their own products or discriminate against business users on their platforms. It will help ensure greater competition and more opportunities for small business and better results for consumers. This bill isn't about punishing successful companies. I strongly applaud American ingenuity and success, but we must ensure that there's a fair and even playing field for everyone on dominant platforms and that consumers aren't harmed. The American Innovation and Choice Online Act is about targeting harmful conduct while ensuring that pro-consumer innovations are protected. My question to Ms. Moss and Professor Albert, how do you, I want to go back to one of the bills that I said I introduced. Over the past few decades, we've seen increased competition and anti-competitive activity in the agricultural industry, including in meat packing, the seed market, and fertilizers. So to you two, how do you think that this has negatively impacted competition and consumers of agricultural products?
Thank you, Senator Grassley. To your question about Competition in the ag biotech industry, AAI has done a tremendous amount of work on this. We now have the creation of multi-level massive behemoth platforms in traits, seeds, agrochemicals, and now digital farming. And I spoke in my remarks earlier about the massive wingspan of these companies. Not to say that there aren't necessarily some efficiencies that might come out of integration, but these companies are so large that smaller innovative rivals have virtually no chance of getting a foothold in the market because they are faced with a company that dominates multiple levels. To your question about the role of Congress, I applaud all of you for thinking hard and seriously about the role of Congress in strengthening, clarifying, modernizing, and updating our antitrust laws to address the types of endemic problems that we see in large companies, exclusionary conduct through discrimination on platforms, cartels that slow down innovation and harm consumers. All of these are needed steps in bootstrapping for our antitrust laws, I think, in the United States. And we really are, I believe, at a pivotal point, where we can look to protect our consumers, our markets, and our democratic principles, or we can slide into a period of very slow economic growth and decline.
Professor?
Yeah, on agriculture, let me just say that I think the biggest problem is you sort of have to pick which seeds and seed varieties and chemicals you're going to use between the different competitors and then stick with them. You don't really have the freedom to pick and choose between some seed varieties with some companies and then other chemicals with other companies. You sort of have to pick which company you're going to go with and do that. With respect to your support and sponsorship of S2992 and the various categories of unlawful conduct that you are proposing to address, I do want to say that there's a lot of good that is happening in this bill. Let me give you, for example, Section 2 on unlawful conduct of S2992 prohibits conditioning access to covered platforms or preferred status or placement on the covered platform on the purchase or use of other products or services offered by the covered platform operator that are not part of or intrinsic to the covered platform. That is exactly the kind of behavior that we're seeing with respect to Google in the online advertising market, where there is a forced tying, a forced connection between, if you're going to use one of their products, say the buyer broker or the seller broker, you also have to use one of their other products. You cannot advertise on YouTube without using Google's brokerage services. It's impossible to do it. So these are the kinds of concerns that I think you're proposing in this legislation that would be helpful.
Senator Blumenthal.
Thanks, Senator Lee. Thank you all for being here today. This topic is one of tremendous interest and importance to this subcommittee, and in fact should be, as you've said, Ms. Moss, to the whole Congress. I want to begin by asking a question about Apple and Google with their total control over what apps consumers can discover and install around the world. That's why the app stores are called walled gardens, as you know, and despite corporate rhetoric about the protection of freedom of expression, both Apple and Google have proven susceptible to pressure from authoritarian governments, which should concern us on both sides of the aisle. Apple has caved to pressure from Chinese authorities to remove tens of thousands of apps from the app stores in China. And they've done it without so much as an explanation as to the laws that the Chinese government claimed were violated. No real protest, no objections, to name a few of those apps. The New York Times apps, which Apple removed while the newspaper was working on articles critical of the Chinese government, abhorrent to our values. Radio Free Asia, a U.S. taxpayer-funded nonprofit news service, and one of the most popular Quran apps in China. Of course, China is not the only country capable of putting that kind of pressure on Apple or Google to cave into their terms. This fall, Apple and Google agreed to shut down the smart voting app in Russia, which was meant to help opposition parties organize ahead of parliamentary elections. Let me ask you, Mr. Harmon, We have an obvious foreign policy interest in promoting democracy, free press, and human rights. These are core American values. They are the values that underlie freedom of expression in this country and our marketplace that enables Google and Apple to make the money that they do. Is it fair to say that Apple censoring protesters in Hong Kong and Russia, even blocking the Voice of America service, undermines our national interest?
I think yes, of course, and they're near absolute monopoly. In fact, absolute monopoly on how you get to apps gives them that power to do that.
My time is limited, so I'll assume that everyone on this panel agrees, unless you would like to say something to the contrary. Thank you. As you all know, 2 decades ago, the Department of Justice and 20 attorneys general sued Microsoft over Windows dominance to undermine competitors in a new, important market, then very new, the internet. I was one of the state attorneys general. In fact, I helped to lead that group. One tactic from the Microsoft playbook of that time strikes me as particularly apt today, Microsoft's desire to collect a VIG for online commerce. I didn't use the word VIG at the time. Actually, it was used by a number of outside commentators. I'm going to put one in the record, James Rill, who referred to it at the time as a VIG. As you know, VIG is sort of a slang term. As a former U.S. attorney, I know well. Used by bookies, meaning they take a cut when they bring bettors together. In 1997, the Wall Street Journal, in this article, which I'm going to ask to be part of the record, if there's no objection.
So be it. It'll be part of the record.
Thanks. They, in effect, collected a VIG for every transaction over the internet that uses Microsoft technology. That's actually a quote from the article. Microsoft actually was never successful in that effort because of antitrust enforcement against the company by those state attorneys general and the Department of Justice. But since then, there have been years of lax antitrust enforcement. And so Apple and Google have managed to do what Microsoft wasn't able to accomplish at the peak of its monopoly power, which is to collect a VIG on every transaction in our app economy. Today, Apple and Google use their duopoly to take a cut of all paid apps and in-app purchases of digital goods and services. Typically, it's 30% off the top. That VIG actually has far more profound impact on most consumers than the VIG collected in those days by the bookies, which was rarely felt by the average or ordinary American. This VIG really stifles innovation and ultimately raises costs for consumers. And if developers don't like that VIG, there's nowhere for them to go. Apple and Google's duopoly gives them the power to say, pay our cut or leave behind all mobile devices. And because Apple set the standard, this monopoly rent fee, I wish it were rent-free, is often referred to as the Apple tax. The Apple tax, a VIG, everybody is pernicious, probably more so than the VIG charged by bookies. So I think I've accurately summarized the current state of play. Let me ask you and Mr. Mizukovsky, isn't it the case that Apple and Google are doing what Microsoft couldn't get away with, essentially charging that VIG, and what is the impact on consumers?
Thanks for the question, Senator. It is it has a massive impact. Companies that get started have to consider both how they price their product for customers, that takes into account the Apple tax, but because of the non-transparent rules that Apple has set up around getting onto their App Store, most companies need to spend weeks, if not months, negotiating and working through a reviews process with Apple just to get onto the store. And this is something that every company that wants to sell a product available to iPhone users needs to take into consideration. I think with the bill that you put forward, along with Senator Blackburn, the Open App Markets bill, puts forward an idea that levels the playing field. It would allow for the possibility of sideloading or installing an app outside of the store, which opens up many opportunities for new ideas, new companies, and new business models as well that don't have to pay the 30% tax.
Thanks, Mr. Mizukovsky. Mr. Harmon, I'm assuming you would agree with that. I've overstepped my time, so the chairman may allow you to answer, but
Go ahead. Oh, please go ahead.
Mr. Harmon.
Yes, I agree, and I think it's important to compare the Microsoft vision pales in comparison to what the reality of what 30%. I mean, I don't think they imagined 30% with their VIG, and Google and Apple have successfully put that in place.
Even Bill Gates didn't have that vision.
Right.
Thanks, Madam Chair.
Senator Hawley.
Thank you, Madam Chair, and thanks to the witnesses for being here. Ms. Mosk, I want to come back to something that you said to Senator Klobuchar at the beginning of the hearing. You talked about the Big Five being on sort of a downward slope in their acquisitions, and it talked about the next generation of dominant platforms. You were thinking about this, and with particular reference to the cloud infrastructure. I'm really curious about that. Could you just give us a sense of who as you look to the future and you think about the next wave here of potential monopolists and the next wave of dominant platforms, who are you thinking about? What are you looking at? What are you seeing?
Thank you, Senator. That's a fantastic question and very much dovetails with the work that I referenced earlier. We at AAI are very interested in the digital business ecosystem sort of as a business model or phenomenon. And what we find is they're very unique. And typically, a digital business ecosystem is built around a platform, whether it's search or e-commerce or advertising, you name it. To support those platforms and the users that engage with them, you need a lot of cloud infrastructure. So you need machine learning technologies, cloud computing, artificial intelligence plays a really important role, data analytics. We find that when those two pieces are in place, digital ecosystems can really expand infinitum. They can add in apps to their ecosystems, whether that's in fintech or health tech or energy tech or ed tech, again, you name it. But these ecosystems have really significant capacities for growth and expansion. And what we've seen with the top five is they have grown monumentally over the last 25 years. 700 transactions, 200 reportable under the HSR requirements, only one challenged Google ITA by the Department of Justice. We are very worried about the activity that we see from an antitrust standpoint, obviously. New players who are quietly engaging in massive levels of acquisitions. These are folks that really fly under the radar screen, who have that cloud technology and capability, they have their platforms in place, and they really are poised to expand dramatically in the next, I would say, 3 to 5 years. Whereas the Big Five have really slowed down significantly on acquisitions. But we have this new generation coming up of highly acquisitive companies with tremendous cloud capability, and those are the ones I think that are very much worth watching as we move into the future. I'm not saying the Big Five aren't worth watching, they are, but it's this new generation, I think, that we need to be very keen on monitoring.
Give us a sense of who is in that category.
I would love to do that. There are public and private companies. I wish I had my list, my spreadsheet, but we have companies in there like Salesforce, which has been incredibly acquisitive over the last many years. Companies like Intuit with an incredible impact in the fintech space. Zillow is building out an incredible platform ecosystem. And these companies don't have enormous market caps, as you might know, but they certainly have the capability to grow, I think, into large market cap companies and have all the same features as the big digital business ecosystems. Just one more quick comment. We worry about these companies because they are really rife with what we call market failures in economics. There are data externalities, there are network effects, there are information asymmetries around the use of data. And so when you have ecosystems or models like that where there are lots of market failures, you're kind of looking at a similar situation to your traditional natural monopoly electric utility. That does require government oversight to make sure that consumers are not ripped off.
Very good. That's very helpful. Thank you very much. Mr. Mizukovsky, if I could just come to you, I wanted to ask you about further action that you think from a policy perspective that this body might take. You mentioned about opening up the App Store. I've sponsored legislation that would mandate data portability and interoperability. Is that something worth pursuing? Are there other steps that we should be thinking about policy-wise in terms of changes to the law that would actually promote competition and innovation and allow companies like yours to have a chance at succeeding as opposed to being shut out by the dominant players?
Thanks very much for your question, Senator. The Access Act, which I think you co-sponsored in the previous Congress, is I think a very important piece of legislation that would support companies like Beeper that are aiming to interoperate with some of the largest tech platforms. I think one of the things that Access does is it enables users to have the freedom to switch away from certain platforms if they no longer continue to agree with those platforms. Right now, most users are locked in because their friends or their current social graph is contained within some of these free apps. If Access were to come to pass, I think that you would see a tremendous innovation in terms of new companies that would compete with some of these entrenched large tech companies. Because no longer would switching mean giving up on the existing relationships that you have with your friends, with your family. You would still be able to maintain those while potentially supporting a different competitor in the space.
Very good. That's very helpful. Thank you. My time has expired, so I will leave it at that. I just want to say, Madam Chair, that I happened to see Mr. Mizukovsky earlier today, and I think this is your first time testifying, right? And I told him this committee is so friendly that he had nothing to fear. So there you are.
Except for certain people. But yes, it is very, very friendly, very friendly. Okay, so next up, Senator Blackburn.
Thank you, Madam Chairman, and thank you all for the hearing today. And I had the opportunity to visit with Mr. Mizukovsky yesterday and had a great competition. I represent Tennessee, and in our state, I think we have the most amazing creative community. And when you look at Nashville and all the songwriters, the TV, the movie production, we have a lot of people that are constantly innovating, and their intellectual property is their stock and trade. And so one of the things we hear a good bit about is access to capital for startups. And, this is something that many times what I hear, and a lot of this is people that are innovating in health IT or in predictive diagnosis systems or in the financial service sector. But then people will say, well, they don't want to invest because they're afraid that you're going to have a Google or an Apple or somebody come in and cut the legs out from under you, and you're not going to be able to actually reap that benefit. So, Ms. Hine, I want to come to you for about 30 seconds on this, and then Mr. Mizukovsky, you. Talk about the problem with access to capital when you have these innovators that are facing these people that are scooping up rather than allowing companies to grow. Go ahead.
Yes, thank you, Senator. It is a problem that access to capital is limited, especially for female entrepreneurs. I think you know that, and those in regions that are not the super centers of venture capital. What big companies do is that they not only buy companies, but they also just copy the features that we bring out, and that does stifle competition. I don't think, therefore, that just limiting acquisitions will be the answer to this. I agree with my other panelists that open API access, for example, is very important. Interoperability are part of the solutions that you could enact.
Thanks. Go ahead.
Thanks for the question, Senator. I think to echo one of the points that Alex was making earlier today, as an investor, we decided to invest in many early stage companies, usually at the stage where it's just one or two people and an idea. But there were certain areas that we had to think twice before we invested in, mostly because of large entrenched players. And I think one that may come to mind is the music industry and the entertainment industry. When we looked at startups that attempted to innovate in these spaces, we always considered how difficult it was to get access to the IP and break into some of these very controlled markets. I think that's one of the reasons why it's more rare to see startups that attempt to reinvent ways of distributing music or content, mostly because of this.
You know, sometimes when I look at this issue on innovation, it reminds me of what we went through about 10 years ago with the patent trolls that were looking at some of the concepts and the apps that were coming online, and it seems to kind of mirror that. Let me have you continue, if I can, on choke points where the startups have a tough time breaking into a market. What would you classify as being these choke points?
One of the choke points that I think we've talked about before is the App Store. That is the primary choke point. That is all roads to iPhone flow through the App Store. On top of that, I think the financial sector currently has many controls that limit how new startups can begin to interoperate. It's getting better. I think there are some startups like Plaid that have innovated in the space and make it much easier for new companies to kind of connect in. Another example is Stripe. But other than that, it is still much harder to build a financial tech company.
Thank you. You will notice, Madam Chairman, that he gave the correct answer in talking about the App Store, and that is why we need the Open App Markets Act.
Very good.
Thank you very much.
Nice summary. All right, next up, Senator Cruz.
Thank you, Madam Chair. Welcome to each of the witnesses. Thank you for being here. The focus of this hearing is innovation, and ensuring that our competition policies drive innovation is critical. But as Professor Alford notes, innovation is just one of the often hidden casualties in antitrust law. Like him, I support the consumer welfare standard. Too often, however, that standard has focused exclusively on price and output effects to the exclusion of things like quality and innovation. The same anti-competitive forces that can stifle technological innovation can also stifle ideas and views that the dominant players disagree with and want to root out. So as I look at it, when we think about how we protect innovation, we also need to look more broadly at how we protect people and companies who dare to think differently. I want to go down the row. Does everyone here agree that it can constitute an antitrust and competition harm when dominant players use their dominance to censor individuals who think differently or just those who disagree with them? Ms. Moss.
Thank you, Senator Cruz, for the question. I think the answer to the question in a nutshell is antitrust is very good at addressing some problems in the digital business ecosystems because they are directly related to competition or a lack thereof. The problem we see with the digital ecosystems is they raise a number of dramatically impactful problems, social problems, political problems, economic problems. I think free speech on the platforms and censorship is one of those problems that may not be that well addressed by antitrust enforcement, but should certainly be addressed by another appropriate public policy tool.
Mr. Harmon.
I think I generally agree with that. I think it depends on the situation and the financial interests of the platform.
Mr. Mizukovsky.
I think the central problem here is that there's a lack of user freedom users do not have the ability to switch platforms if they no longer agree with the platform, or if they want to try a new service. There's a lack of interoperability and data portability. I think that the American Innovation and Choice Online Act goes to great lengths to make this a much more level playing field.
Thank you. Professor Alford.
So, I mean, I will echo some of the previous comments. I think there's a lot of things that are happening with respect to these big tech companies, and only some of them relate to antitrust law. So, for example, issues of censorship, issues of addiction, issues of mental health and wellness, a lot of those issues don't directly relate to antitrust issues. They are very serious concerns, but it's difficult to fit those square pegs into the round hole of antitrust. But I do think that you can say that to the extent that censorship constitutes harm to the quality of the experience for the consumer, then it would be a colorable claim that you could make under the antitrust laws. I would also add that to the extent these big tech companies say that they do not discriminate against conservatives, and they can show that that's a misrepresentation, then they also could be liable under the consumer protection laws.
Ms. Hine.
I have to agree with most of the other panelists that antitrust is probably not the right thing to address freedom of speech and censorship. I do think, though, that critical voices and new ideas are the lifeblood of innovation, and that should not be stifled.
So again, to each of you, when we tackle issues of competition and innovation, should we think broadly about what it means to innovate? That is, think beyond simply technological innovation and look more broadly at innovation that serves a clear market demand, a consumer demand. Mr. Mizukovsky talked about consumer freedom. One example of innovation to serve a market demand is Parler, which was created to serve a demand in the face of widespread censorship of conservatives. Parler was created, and then Google and Apple and Amazon all used market power to coordinate to block the competitor and drive them out of business. Ms. Moss.
Thank you. I think where competition becomes very important in this particular debate, and certainly free speech is a backbone of underlying democratic principles which support a market-based system, is to encourage competition and entry by smaller innovative rivals in spaces that are dominated by large platforms, regardless of their political inclinations or not. The mechanics are such that kicking off smaller rivals for whatever reason, limiting users' ability to switch and not be locked into a particular system, all contribute to a diminution in the number of voices that are out there in the free speech context. As Roger pointed out as well, and others have said, antitrust would have a hard time getting at that problem through methods of deterrence and how to remedy that type of issue. But certainly more competition is always better in that context. But I think, as I said earlier, we need other public policy tools to address some of these stickier issues.
Mr. Harmon?
Yes, I think we should be thinking about innovation as removing the barriers, especially in the big tech space, removing the barriers that the dominant platforms have put in place to protect themselves, so that innovators, as they're at the very first stage, at the finance stage, at a mature stage, they are not bound by the strictures that these companies put in place.
Mr. Mizukovsky?
Senator Blumenthal mentioned earlier that there are not just considerations in the App Store here in the United States, but also internationally, that foreign governments have taken action in removing apps from the App Store there. I think it all comes down to the ability for people to decide for themselves which apps they would like to use. And as of right now, people do not have that freedom to choose on platforms like the iPhone.
Professor Alford?
Yeah, so in my prepared remarks, I discussed quality fixing in addition to price fixing. And you and Senator Lee have both talked about the Parler example in which Google, Apple, and Amazon have kicked off Parler. And to the extent that one could show an agreement between Google, Apple, and Amazon to raise the same identical quality concerns with respect to the reasons for why they decided to kick Parler off of their platforms, I think that there could be a quality fixing argument. And as I suggested in my opening remarks, I'm surprised that there's not more subpoenas or investigations with respect to big tech companies when they are engaging in quality fixing, such as let's develop a common position, let's get on the same page about this privacy concern or this desire and effort to squelch conservative voices. To the extent there is potential evidence of quality fixing, then I think there should be investigations of that.
And Ms. Hine?
I think the other panelists have given you good input on that. I am not an expert on which apps to remove from the App Store or not.
Okay, thank you.
Very good. Thank you, Senator Cruz. I have a few additional questions here. I guess I'll go to you, Mr. Harmon. We have heard a lot of misleading claims on TV. Senator Grassley and I have to deal with these, that we are somehow going to get rid of Amazon Prime. That's one of my favorite ones. When, if you look at the bill, it would not do that by any means. But could you talk about what the bill actually does, which is to prohibit platforms from abusing their gatekeeper power? Would these type of rules help or harm businesses that rely on Apple, Google, and Amazon to reach their customers?
Thank you, Senator. Yes, these are misleading claims. I think the starting point is what is a platform, and Amazon Prime is not a platform. If you are a business user of these platforms, you are at the mercy of those platforms to get access to their user, to their customers, to your customers. You're at their mercy on their terms of service that are totally subjective to their whim to change. And this bill gives you the ability as a business user to have a fair playing field so that you're not going to be unfairly discriminated against because of your potential threat to their platform dominance.
And would Amazon be forced to cancel Prime or free shipping because of this bill?
Absolutely not.
Okay. Also, numerous recent reports have suggested that Amazon creates knockoffs of third-party sellers' products and uses its algorithms to give its own brands an advantage. Part of this was reporting in Wall Street Journal, other places. How does this practice affect competition and the incentives of small businesses to create new innovative products?
Yes, I think this is an example of, I mean, it's patently unfair, right? It makes all of us upset, but it's also an example of in this case, Amazon, this dominance of demonstrating to your users that if they don't fall in line, this is what can happen, right? They are at your whim. You want to sell your product, you have to do everything they do and not upset them and not be too successful, because then they might step in and remove you.
Mm-hmm. Very good. I think that's how a lot of people, and sometimes I wonder if members around here, people are when you've got monopolies and they have a lot of power, you don't want to piss them off. That's the problem with the monopoly. And so I hope people take this to heart, because one of our jobs is to look out for the public interest and to look at what's really happening. And it's right in front of our eyes, whether it's what you heard from the whistleblower on Facebook, whether it is what we're hearing from companies as big as Spotify and Tile and Match.com about what's going on the app stores, or whether it is what we're hearing from small businesses and startups like Mr. Mizukovsky's, who are simply trying to compete with some really good ideas. Or it's whether what we hear from the companies themselves. I think it was Mark Zuckerberg's infamous words in an email where he said, "I'd rather buy than compete." I think that's about as clear as we can get. Professor Alford, you previously worked in the Antitrust Division of the Department of Justice. We consider that a badge of honor around here. When you were at the department, how did you handle questions around innovation when pursuing cases?
So they would always, typically in the merger context, they would always be part of the analysis. They would be part of the questions that would be arise. There would be requests on document production related to issues concerning innovation. And to the extent that there was a potential risk to innovation as part of the merger, then they would address that appropriately. And so in some cases, it meant, as I suggested in my written testimony, it meant that there had to be a divestiture of certain assets to maintain R&D or to maintain intellectual property. In some cases, the harm to innovation led to a decision to block the merger altogether. And as I mentioned, the example of that would be Visa's attempted acquisition of Plaid. So I think in the context of conduct cases, I think I did not see specific cases during my time there where harm to innovation was part of the specific conduct cases because, you know.
Why do you think that is? Because the horizontal merger guidelines explicitly reference innovation, including considerations of whether merger is, quote, likely to diminish innovation competition.
Well, I think there's a variety of answers to that. I think there's a tendency at the enforcement agencies to focus on price and output. There's not a sufficient attention on issues related to quality or harm to innovation. And there's a reluctance in some cases to bring innovative litigation that has a less likelihood of success. So there is, I guess, error cost analysis, you could say, where I'd rather be safe and not bring a case unless I have a high degree of confidence. And so I think there's a movement afoot, a bipartisan movement afoot, to bring more cases and recognize that that as long as a case is plausible under the existing antitrust laws, it's better to be slightly more aggressive than conservative with respect to bringing litigation. But I think that's a relatively recent development.
Right.
When I was there, the overwhelming majority of the time, the concern was Europe is focusing on these companies. Where is America? Where is the United States?
Yeah.
Right. And it wasn't until, as you know, the very, very end of the Trump administration and now with the Biden administration that we're really, I think, focusing on these issues.
Well, and I've appreciated that it's gone between, two very different administrations with different leaders in the agencies. But I think it shows, and some of the more successful antitrust suits have been like that. They have been crossed political party lines. And one of the things that I talked about at length, and he was helpful on, as your former boss, Mika Delrahim, was about the resources for the agency. And do you think the agencies need more resources?
Yes, I love Section 15 of your bill where you're proposing, $300 million extra for the Department of Justice and something even greater than that for the Federal Trade Commission. I don't think anyone in the DOJ or the FTC will be opposed to that.
Yeah, well, there's two things going on. One is the bill that Senator Grassley and I passed through this committee, and it's now over in the House, actually. It got through the U.S. Senate to change the merger fee standards, which was supported by this committee, and it's over $100 million long-term. Go ahead, Mr.
Well, I was going to say that of all of the antitrust bills that have been proposed in the House and in the Senate, I think the merger filing fees and the reforms with respect to that, and as well as the Venue Act that you also have co-sponsored.
Senator Lee is the lead on, yes.
Exactly, that Senator Lee is the lead on, exactly.
Okay. And then the other thing is we also have additional funding. Well, there's the budget, but also in the bill we're considering right now in the Build Back Better bill. So I was going to ask you, Ms. Moss, just about pharma here at the end, because we've been focused on tech. As you know, many of my bills are actually more generic, not to use a pharma little play on words, but they are not just about tech. They're about changing the standards in some limited cases, but important big cases, as well as looking at all industries, because I think the tech is unique in that we've done nothing since it started in our federal law. We've done nothing on federal privacy. We've done nothing on updating many of our laws when it comes to tech because they've said, leave us alone, and everyone said, okay, and now look where we are. But I do want you to give you that opportunity because there's been a lot of support on this committee, including with many Republicans on taking on some of the pharmaceutical issues. We just recently passed 2 or 3 bills out of this committee related to patents and the like. To talk about what you're seeing in pharma consolidation.
Sure, thank you. So pharmaceuticals and healthcare more generally are some of the most consumer-facing sectors we have. Prices matter to consumers. Drug costs are high in this country. They're a major part of total healthcare spend. We count on innovation, robust innovation amongst the branded pharmaceutical companies to have parallel path R&D competition, head-to-head R&D competition to produce new branded drugs that make it through to the commercialization process. We count on the generics to be first to file, racing to the finish line to get to that abbreviated new drug application. That's almost a form of innovation in terms of lowering cost to consumers. We see generics now innovating in the super generic space because of the defense patents that are put up by the branded drug companies. But this is all on the decline. If you look at the return on R&D and pharmaceuticals, it is absolutely in decline. And we have strong research, as I noted in my testimony, that says the more competitors you have in the market, the more productivity you'll get out of the R&D process itself. I don't think the FTC's merger policy on pharma has been very helpful. The study we did back in the spring is a real eye-popper. 67 companies allowed to merge with very targeted divestitures. I mean, we're talking about therapeutic value or even molecule-defined markets. So we need to revisit how we look at pharmaceutical markets in the antitrust context. Remedies are beginning to have a bad name. The larger the company, the more concentrated the merger, the more pressure there is on a remedy to restore competition. And that goes, for price competition, quality competition, innovation competition. We're seeing a growing list of failed remedies in all sectors, and including in the pharmaceutical sector specifically. So to revitalize competition and innovation competition in pharma, I think is going to take some major changes in how antitrust enforcers look at those mergers and the policies they pursue. But I strongly need support from Congress and the bills that you have put out, which would be designed to support stronger enforcement, but to also address some of the issues that we have elsewhere in the intellectual property space, in the FDA drug approval space, and opening up possibilities for innovative products like biosimilars and supergenerics.
Okay, just 2 follow-ups, last, not on pharma, just because these are things that we keep getting, and I really want to get on the record some answers to these. Mr. Harmon, last week in the Commerce Committee, I questioned the head of Instagram about how aggressively his company is targeting teenagers. In fact, there was a document that showed one of them, people that present work there, said it'd be existential threat to the company if they lost teenagers. And it showed marketing increases to their budget. This all came out of the Facebook whistleblower document. Is it possible that Instagram might have developed better features to promote user privacy, safety, and security if it had not been bought by Facebook, now Meta?
Absolutely, and other apps could have developed as well that wouldn't have had to face the dominant Facebook, Instagram, WhatsApp monopoly.
Mm-hmm. How does a consolidation of the tech industry deprive consumers of real choice and innovations that could solve issues? I think everyone always thinks price, very important, right? But there's other things. There's bells and whistles about misinformation, privacy violations, harmful content.
Yeah, I like to think of it as the things we don't know we're missing, right? The innovations that didn't get off the ground because people didn't want to, or were crushed, but didn't want to take on what was an insurmountable threat to Facebook or to Google or to Apple.
I think in the case of the Instagram and kids, I think a lot of parents know something's missing, though. Their kids are seeing all this crap they don't want them to see. They can't get addicted to their phones at age 10. And yet, these companies are the biggest companies the world's ever known, and they could find out like who's using their phones and create some limits on it. But it's not in their best interest because I think it's their interests, as I said the other day, are diametrically opposed to the interests of the parents because they want them on those phones because they want to get the marketing revenue. Last question, Mr. Mizukovsky. In recent weeks, we've heard a lot of misleading claims from groups funded by big tech. There are a lot of groups funded by big tech that have really nice sounding names, as you know. One claim I've heard is that this bill would force Apple to allow unsafe apps on consumer devices. We don't believe that's true because of the standards in the bill. And our bill has a specific provision enabling platforms like Apple and Google to take action to protect safety, user privacy, and security. We'll continue to work with them on this, not much longer, because as noted, I think we need a little less talk and a lot more action around this place when it comes to. Someone was complaining about the timeline. I'm like, what do you mean? 25 years that we haven't done anything? Apple does not allow consumers to download apps on their iPhones outside the App Store. And they say allowing side loading would expose consumers to unsafe apps. As you know, Google does allow other apps on there. In your knowledge as an entrepreneur and engineer, can Apple allow users to sideload apps on their iPhones and still protect their privacy and security? Just one little clue. iMacs allow other platforms on there. So, but continue on.
I think the simplest answer is that Google currently allows other applications on the Android operating system, and the sky has not fallen. So the same should.
Well, and also I meant Macs, not iMacs, but Macs, their own product allow
any sort of application to be installed. I mean, that was the core foundation of computing, 30, 40 years ago when computers started becoming multi-purpose devices. It was hackers and innovators creating new experiences that no one ever thought of before. Mm-hmm. Part of the way that we can do that is by quickly iterating and building new ideas. That is definitely not the case on iPhone.
Mm-hmm. Very good. Senator Lee.
Okay, first I want to go back to Ms. Hine. I want to give you a chance to respond to some of Senator Durbin's comments a little while ago. The quote that you shared in your written testimony about Sarbanes-Oxley is one that I've seen in a number of contexts. It is haunting. It's haunting to me, not just as a member of this subcommittee in particular, but it's a signal to me that we ought to be careful. We ought to be cautious always when wielding government authority, that by purporting to solve one problem, we not create a lot of other problems, and that we not thwart innovation and competition. Do you want to respond to that?
Well, that's exactly the point, Senator, that I've been trying to make. All of this legislation, Sarbanes-Oxley, Dodd-Frank, very well intentioned, but as economists say, there are distortions and things, unintended consequences of this, and therefore I'm critical of things where we don't know how they will play out, and therefore I think that specifically the point I've been making is around acquisitions, that there is no real reasoning right now why a certain number of companies cannot or have larger hurdles to acquisitions.
Right. And so still using Sarbanes-Oxley as a model then, I mean, as Senator Durbin points out, there were issues that led to that. Now, I happen to not agree that Sarbanes-Oxley was the only answer that could have been concluded. I don't think that was the case. But the fact that there are legitimate reasons that cause Congress to be considered, and then actions taken by Congress through a change in law to create additional obligations that can be put in place by the overpowering force of the federal government, the fact that there are somewhere along that chain legitimate concerns animating those doesn't obviate the need to look for negative unintended consequences on competition. You agree with that?
Yes, Senator, I agree with that. As I mentioned, I don't think that the sledgehammer of legislation is necessary here, but actually adding those resources to the FTC and the Department of Justice to look at these things very individually and figure out what are actually the aspects of that anti-competitive behavior that need to be stopped. You gave a good example there with advertising technologies and being on the buy side and the sell side. Those are exactly areas where action is needed, and that has nothing to do with acquisitions.
Thank you. Professor Alford, a few months ago we saw actions taken by 3 tech giants, Apple, Google, and Amazon, over about a 48-hour period to take down what was then a new and budding and somewhat promising social media platform called Parler. Now, I don't know to what degree they were coordinating that or they were colluding in doing that. What I do know is that all 3 of them took action at almost exactly the same time with near surgical precision in order to take down a much smaller company, one that, as best I can tell, didn't compete with any of them. This is concerning to me. And, you know, since then, Parler has been able to get up and operate again, but they were badly wounded in the process, and the astronomical growth that they had seen up until that point halted. When you halt that kind of growth, it tends to lose its momentum. I'm not sure where they are now, growth-wise, but this is concerning. It raises questions in my mind. Do you want to help me understand, how do we distinguish between legitimate standard setting and the collusive quality fixing that you mentioned in your testimony?
Yeah, I mean, you've raised this issue numerous times, and I think it's an incredibly important issue to think about. I mean, if you think about alternative platforms that might be able to compete with Facebook, one can well imagine the network effects that would result from a mass migration of essentially conservative-minded people wanting to go to another network, just as one can think of TikTok as a mass migration of really, really young people wanting to go and migrate toward a really young platform. You can certainly imagine a world where there would be a plurality of platforms, and they could break off on a whole variety of different lines, including regarding political alignment. And so I think that they viewed Parler as a very serious threat. And as you said, you would have to show, I mean, to the extent that Google, Apple, and Amazon colluded with one another and coordinated with one another to say, yeah, let's use the same arguments, you know, together at the same time to take down the app and do it, as you said, within a 48-hour period, that definitely should raise alarm bells. I don't know why there has not been CIDs issued to these companies with respect to quality fixing like that. I think the larger point that you raised, though, is that the fact that they feel that they can do this suggests that these companies themselves know that they are monopolies, right? As you put it in your speech to NetChoice, conservative anger at big tech is real, and it's entirely justified. No business would treat its customers with the prejudice and disdain shown towards conservatives by big tech unless that business were confident that it was the only game in town. So I think at a minimum, it reflects the power that they feel.
So while not independently a violation of antitrust laws, perhaps, it certainly is not the kind of activity. In other words, if you aim your audience, insofar as you're talking about a marketplace consisting of Americans, of the American people, it would cause one to wonder why and under what circumstances a company would deliberately alienate roughly half of its potential user base or customer base.
Exactly.
That in turn suggests perhaps a need for another look
Exactly.
Dr. Moss, we talked a little bit earlier, and you've spoken with some of my colleagues about the pharmaceutical industry. I think this is an interesting one. It's an interesting angle from which to view competition, because you have such a highly regulated industry, one in which you can't do anything without, not just that without being regulated once you produce something, but long before you get into the production pipeline, you have to go through a million steps, costing an enormous amount of money in order to get there. As a result of this, you have a lot of companies that never really can make it to production. They will always be acquired. That's part of their business plan, is to be acquired, because they don't have all the resources to make it through to and then through the phase 3 clinical trials and everything else that goes along with it. So getting acquired is not only part of the plan, it's the entire plan for many of them. How do you solve that kind of regulation-induced consolidation? Or, I mean, is it first something that we ought to worry about? Is it something we should try to solve? If so, how would we go about doing that?
Thank you, Senator Lee. So R&D is a risky process, for sure. I think in pharmaceuticals, the chances of actually realizing a fully commercialized drug that has made it through clinical trials and into the hands of physicians and other healthcare providers is probably one of the highest risks that has been experienced. I think the crux of the issue with innovation competition and its decline in pharmaceuticals lies directly with consolidation in the branded drug companies, but also in the generic space. And this gets back to the elimination of parallel path pipelines, racing to be the first to file, entry by generics into the super generic spaces, et cetera. And what we see, or at least what some good economic analysis shows us, is that this level of consolidation has created sort of a bulge in the development end of the pipeline, where you have very, very few companies, fewer and fewer companies, actually shepherding along that final leg in the process to get the drug into the commercial zone. And that's where the FDA comes in, right? And the application processes and that sort of thing. So more competition to smooth out that bulge in that development part of the pipeline would be really, really important. As far as the startup model or the kind of the nurturing the smaller, riskier businesses, I don't have good answers for that, unfortunately. The one thing we've learned in the digital tech space is that VC-backed startup model is very, very much part of the growth of the big tech ecosystems. And I agree with you, Senator, that it's also part of the growth in the pharmaceutical space. So these companies have actually fostered the development of a pipeline of new talent in the form of startups. And those startups are often, as I said, backed by venture capital. However, that very model, the existence of that very model, and the desire to be acquired as opposed to grow into a fully fledged rival, like Senator Klobuchar was just saying, that in itself is a distortion of competition, because those companies are going to be innovating differently if they want to be acquired versus if they want to go it on their own and stay independent as standalone rivals and challenge the incumbents with significant market power. I don't know what you do with that model from a public policy perspective, but I don't think good policy is protecting that model, because the digital tech companies say, well, these are the people we want to buy, this is how we grow, and then the small startups want to be acquired and are thus directing their R&D in areas that are designed to maximize their purchase price. That's why I think we need strong antitrust enforcement and stronger standards for acquisitions of potential rivals, which are included in the Calera bill, as well as other protections.
Right. You can also see, I always think about industries that are either born into regulatory captivity or born into regulatory freedom. You see this elsewhere in other heavily regulated industries, some of them by the same regulatory bodies. The FDA, for example, also exerts its heavy hand in things that are not pharmaceutical products, but things like the owlet sock that I mentioned a minute ago, where you just have moms and dads who want to be able to monitor their baby's heart rate and oxygen levels remotely. It's a convenient way of doing this. It's not a device that promises or purports to be there for diagnosis or treatment of any medical condition. They just rest a little easier being able to look at a number and say, yeah, that looks like things are going well in there. And they don't have to go walk into the room risking waking up the baby. There are a whole bunch of people in Utah and elsewhere across this country who are now very upset that they can't get this thing. Word spreads. My daughter-in-law, Claire, was recently at a friend's baby shower, and a lot of the moms there were complaining about the fact that you can't find an outlet. They were scrambling about where to find one on the secondary market or, to buy one used. And all this because a busybody regulatory agency decided that it had to get involved. And as a result of this, people aren't going to enter in and compete. I worry about what that says for so many other industries. And I think the FDA has had a nice long run, but it's been given way, way too much control over our entire economy. I think they need to remember that they're not elected to anything. They don't have power to make new laws, and they're acting as if they were the masters of the universe. I think it harms competition. I assume you wouldn't disagree with me that the regulatory power of the FDA and other agencies for that matter extends far beyond the pharmaceutical industry and into other areas where it could have all sorts of consequences that are not only unintended, but very unpleasant.
As an economist, I have to mention, of course, that there is this thing called regulatory capture, which we do worry about. I'm a former federal regulator myself over at the FERC for many years during the open access rule, and saw the rough and tumble of vested interests in large dominant firms wanting regulation that would actually make their lives easier as opposed to inject oversight and competition into the market. So we should not forget that regulation, good regulation, well-structured regulation that achieves objectives with minimal side effects or distortions is really an important goal. Second, I think it's worth mentioning that if we want to stimulate innovation competition for the benefit of consumers and workers and entrepreneurs, we cannot apply a one-size-fits-all regulatory model to everybody. So case in point, I did a podcast, an AAI podcast, Ruled by Reason, with two really innovative entrepreneurs in the beef sector. These are small independent cattlemen. They have innovative ranching operations. They are essentially microprocessors. Well, these guys can't compete because the USDA imposes standards on them for food inspection, animal inspection, that they would impose on a large packing facility. So it's really expensive and hard for these smaller players to be innovative and enter markets when they are subject to one-size-fits-all regulation regardless of size.
Thank you.
You kind of lost me at Masters of the Universe. I was thinking that wouldn't be a bad title to have right now around this place. Try to get some things done. Okay, so I just want one follow-up here, I guess from maybe two of you. Ms. Hines testified in just the latest questions from Senator Lee that small entrepreneurs would be hurt by legislation to limit serial acquisitions by dominant platforms. Do you agree, Mr. Herman?
No, I think it. I would like to associate myself with the comments of Ms. Moss. I think it is a market distortion that everything is focused towards being purchased or not upsetting the dominant players. And I think getting the dominant players out of that market will cause innovators to be able to the sky's the limit. Build what they want and not be afraid of the consequences from big dominant players who control the market.
And I just always figured out that our laws have to be as sophisticated as the economy that we're dealing with. And I think it's one of the reasons you've seen bipartisan support on the merger issue. Honestly, there are a number of people that are supportive on the conservative side, including Macon Delrahim on the taking that merger standard of flipping the burden for the biggest deals and extending it beyond tech. But that being said, I think it's very important to note we're dealing with several different bills here. One is on the merger issues. I have one that would cover all aspects and different players, and not just in tech. Senator Cotton and I have one that's focused on tech. Then we have the bill that I wanted to focus much of the discussion, which it has in this hearing, on some of the exclusivity conduct. And this is what Mr. Mizukovsky is getting at, where these platforms are favoring themselves over others. And it wouldn't mean the platforms go away in any way, nor does some of their very important offerings. But what it means is that you just have some fairness. Because there's been no rules of the game set. And that is the bill, just for anyone watching at this late hour, that Senator Grassley and I have put together with the Ocean's 11 of sponsors. That was Samantha Bee's line. And then we have app stores, which is a specific focus very related to the exclusivity and the non-discrimination bill that we put forward. And then we have other bills, which Professor Alford was focused on with the helping the agencies, and Ms. Hines mentioned as well the need to have good people in these agencies who are doing their jobs. In a moment where we're seeing more and more consolidation, there's going to be more and more mergers coming before these agencies across the board, and we have to make sure they have the resources that they need. So that's another area of focus. Then we have bills related to pharma and agriculture consolidation that we've had hearings on in this subcommittee, as well as the work being done over on the commerce side. Again, back to tech, but really across the economy on privacy and sharing data. And Senator Cantwell's leading the efforts on that, as well as some kids-specific legislation on protecting. And then we have Section 230, which we blissfully did not discuss at length. I say blissfully because we could have a lot bigger discussions and have had on this committee, as well as not just subcommittee, the committee, which is something that, if everything is stalled out here as the tech companies put millions and millions of dollars up on TV ads, specifically targeting my colleagues in the Washington, D.C. area, I would hope that they are smarter than that to realize that's why they're getting targeted on late night TV when they come home from work. Or the 2,500 tech lobbyists that have been hired. I would hope that they see beyond that, because at some point we're going to have no choice but to make major changes to Section 230, because if we can't get anything moving, which maybe you could describe as the more chisel effect in terms of going after, on the merger side, going after the anti-discrimination conduct, or the pro-discrimination conduct that's happening right now, going after privacy. So my view is I'm going to get there too, to where a number of my colleagues are. It's just getting rid of any immunity at all. Right now I have targeted immunity bills if we don't get something done here. And I'm speaking now to an empty room, but it's not because the senators weren't here. They were here in droves, which I really appreciate. But in terms of interest of the Senate as a whole, that's what we have to see in the next few months. We can't wait. An election is upon us. We've got to get the markup in January on a few of these bills. I would suggest the exclusivity bill, the bill that I have with Senator Grassley. I would also put on the record the recent piece he wrote for the Des Moines Journal, Des Moines Register, on the bill, as well as the number of these other pieces of legislation. We just have to stop talking about them. I don't want to have any more hearings with CEOs and throwing popcorn at them. We need to have action and get this done. And that is not for you witnesses who are valiantly stuck through until 5 p.m. at this hearing, but it's really for my colleagues and the rest of the Senate especially, that it is just time to bring these bills up for markups, no more hearings, markups, so that we can get them to the floor. You know, Professor Alford, two of the bills, one's passed the Senate merger bill, the other the venue bill, which is now headed to the floor, as well as a few other bills that are focused on farm and other things. That's great. But we have to get some of these tech bills to the floor so we can get the floor time to actually pass them. So that is my goal. Less talk, more action. With that, the hearing record will be held open for more talk for another week, I believe. And with that, the hearing is adjourned. I want to thank Senator Lee and all the senators that participated and been incredibly active on this issue. That part of it has been heartwarming, actually, because we are up against a lot. We have 2 lawyers on our staff that do antitrust. They're sitting behind me. They're a mighty group. It's kind of a Saving Private Ryan situation with Avery and Mark. And the tech companies have 2,500 lobbyists and probably 10,000 lawyers. But I believe in the movie Saving Private Ryan. I believe a small but mighty force can win. And that's what we are doing. That's what we're up against. But we've got the momentum on our side because we've got the people of this country on our side. Thank you. Hearing's adjourned.